Um, Good morning, ZTP holders. I'm actually recording this video because I thought it was necessary to address some of the issues that were raised in the media statement that was issued by the Department of Home Affairs by Mr. Thabo Mohola, which is dated the 7th of November 2023. I had not taken time to go through that media statement as well as the full judgment, of the court in the enforcement application of the Helen Suzman Foundation and the COMSA, applications. It suffices to mention that the crux of that application was based on the Minister, one, stating that the June order was a final order, and the judgment on this application is very clear that that application is not a judgment is not a final order, and therefore the Minister of Home Affairs or the Minister of Home Affairs cannot claim, any success, because the fallacy that they were putting forth that the order given in June is a final order was dispelled, and the victory, I think, that seems to be celebrated by the press statement is in a very huge way, I think, misguided, on the fact that the Helen Suzman Foundation as an organization has got every right to take any institution to court, especially when there are certain rights that need to be protected, not to be attacked, as it appears that it continuously, gets to be attacked. And the opening statement, which is paragraph 1, says, the Minister of Home Affairs wholeheartedly welcomes the full court judgment on the enforcement application in the Helen Suzman, dismissing the ill-conceived enforcement application brought by the Helen Suzman, joined by the COMSA. Now, the dismissal is not a dismissal per se, because it clarifies the position that what the minister sought to put forth, that this was a final order, and therefore, they could not, enforce, they could not be bound by it because they were appealing it, and also that based on the fact that, they had appeals, so they had other alternatives. Now, the very fact that the minister says in the communication between the lawyers that they were not going to abide by those requests and were making a lot of refusals to comply with those letters that were sent, by the legal representatives of the Helen Suzman Foundation, showed the position of the Department of Home Affairs. Now, the fact that the judgment in the in the enforcement application clearly states that that is an interim order, and that the need to apply even enforcement is not necessary, because that order as it stands, it is protection enough. It merely clarifies that position, and that is what the Helen Suzman Foundation sought to get to the point, so that, for the avoidance of doubt, it was clear that it's an interim order, and that the Department of Home Affairs contention could not therefore stand. Now, the second paragraph from this media statement says the Helen Suzman Foundation adopted an opportunistic approach of seeking 50% personal cost order against the minister. This was too dismissed by the full court, and that the Helen Suzman has been launching applications in court against the minister in the so-called public interest. The question is where public interest in the end its fellow travelers serving is whose public interest. In essence, Helen Suzman Foundation and COMSA sought the judgment whereby the court will issue an order to compel the department to implement the adverse judgment regardless of any subsequent appeal by the Minister of Court. The judgment must serve as a wake-up call to the affected Zimbabwean nationals to follow the procedures outlined by the minister to regularize their stay in the Republic and forget about these promises. I must be very frank and say this is very appalling, especially coming from a whole department headed by a minister, to have this kind of writing. One, to attack an organization like the Helen Suzman Foundation and COMSA, who are merely acting, in the interests, in the public interest or in the interest of justice, and have taken, the matter, to court.